Pleasure for being here and giving a small lecture on the subject Introduction to Insolvency and Bankruptcy Law. Hello friends, I am Sandeep Bhuraria, and I thank Diksha and Law Leveler for giving me this opportunity to give a brief talk on the Introduction to Insolvency and Bankruptcy Law. So what is insolvency and bankruptcy law? The insolvency and bankruptcy law was introduced by an act of parliament in the year 2016 by the then finance minister, the legendary late Mr. Arun Jaitley. Prior to the enactment of the insolvency and bankruptcy laws, there were multiple acts which were dealing with a resolution process of corporates as well as individuals. You would all know that for the resolution of corporates, the law was SICA, Sikh Industrial Companies Act, and the forum was BIFR, Board of Industrial and Financial Reconstruction. And for individuals, the insolvency law was the Provisional Insolvency Act of 1920. But because of these multiple forums and the multiple laws, there was extreme delay in adjudication of the insolvency of corporates as well as the individuals. Hence, the then Vishwanath Committee was set up under the chairmanship of Mr. T.K. Vishwanathan, former Secretary General Lok Sabha, and the former Union Law Secretary, to go into the various aspects of insolvency of corporates. This committee was set up on 22nd of August 2014. And this committee, after studying the bankruptcy laws of various countries, gave a final report on 4/11/2015 to the then Government of India. The Government of India, basis this report, submitted a draft bill in the Lok Sabha on 21/12/2015. This bill was introduced in the Parliament by none other than the legendary late Mr. Arun Jaitley. This bill was then referred to a joint committee of the Parliament, and basis that report of the joint committee, the bill was passed in the Lok Sabha on 5th of May 2016 and the Rajya Sabha on 11th of May 2016. This code received the assent of the President on 28th of May 2016. By virtue of this law, the Provisional Insolvency Act of 1922 was repealed. The Part 1 and Part 2 of this code was notified on 1st of December 2016. Now, it is important to understand this Insolvency and Bankruptcy Code. I will take you to the relevant provisions of this code. The relevant provisions are there on the screen. This is Section 2, subsection 11, a debt. What is a debt? Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt as well as an operational debt. Then Section 2, subsection 12 defines default. A default, as per the provisions of this code, means non-payment of a debt. Now, a debt could be both financial as well as operational. when whole or any part of installment of the amount of debt has become due and is not paid by the debtor, now, or the corporate debtor. Now, Section 5, subsection 8 defines a financial debt. What is a financial debt? So as you would see, Section 211 defines debt. Now, there are two kinds of debts, financial debt and operational debt. Section 5, subsection 8 defines a financial debt. A financial debt means a debt along with interest, if any. Now, this is very important, if any. I'll explain why it is important. Which is dispersed against the consideration of time value of money. Now, Section 5, subsection 12 defines an operational debt. An operational debt means a claim in respect of a provisions of a goods and services, including employment claims in respect of payment of dues arising under the law for the time being in force. Now, so financial debt is a debt which is due to a financial creditor. And Section 5, subsection 7 defines a financial creditor. A financial creditor over here means any person to whom a financial debt is owed and includes a person to whom such debt has also been assigned. Section 5, subsection 20 defines an operational creditor. Operational creditor would mean a person to whom an operational debt is owed and includes any person to whom such debt is defined or is assigned. Now, after this, I will take you to Section 7. Section 7 is initiation of a corporate insolvency resolution process by a financial creditor. So, my friends, what is Section 7? Section 7 here is when a financial creditor, there is an amount due to a financial creditor and that amount has not been paid, which means that there is a debt and there is a default, and which will then help a financial creditor to initiate CIRP proceedings against a corporate debtor, and for that he will have to take help of Section 7. Now, Section 7 can be filed by a financial creditor. It can be filed jointly with other financial creditors and any other person on behalf of the financial creditor. Now, any other person on behalf of the financial creditor would mean any person to whom that financial creditor has assigned his debt. Now, the question is, when can an application under Section 7 can be filed? An application under Section 7 can be filed when there is a default in payment of the financial debt by the corporate debtor. Now, if you would recollect, I had said that when I was going through the definition of financial debt, I had paused for a minute at if any. Now, my friends, why this if any word is important is Honorable Adjudicating Authority, which is National Company Law Tribunal, and the Appellate Tribunal, which is National Company Law Appellate Tribunal, had in various judgments held that to be able to initiate our proceedings under Section 7, it is important that there is a debt which is against a time value for money. Now, they repeatedly in various judgments held that there has to be a financial debt, and the financial debt must be an interest-bearing debt. Now, this position of law was then questioned by Orator Marketing Private Limited to the Honorable Supreme Court. And the Honorable Supreme Court, in this judgment, Orator Marketing Private Limited versus Samtex Designs Private Limited, held that it is not necessary that any financial debt must be interest bearing. And they relied upon this word, if any, because if you would go, I will go through this definition again. A financial debt means a debt along with interest, comma, if any. So it is not necessary that the financial debt must be an interest-bearing debt. It could be an interest-free debt, which means it could be a friendly loan. And hence, the Honorable Supreme Court in Orator Marketing held that financial debt necessarily may not be an interest-bearing debt. Now, after this, I am taking you to the amendment to the definition of a financial creditor. Now, if you would recollect, friends, that there was an amendment in the definition of financial debt, financial creditor, which actually brought in the allottees of a real estate project as a financial creditor. Now, why was this done? This was done that because, if you would recollect, that there were two large real estate companies like Amrapali and JP, which had defaulted in delivery of flats, units to its home buyers. And there was a hue and cry all across the country because of these defaults. And the then legislature, in its wisdom, decided to amend the code via the Insolvency and Bankruptcy Code and included the allottees as financial creditor under Section 5, subsection 8, subclause F, to allow them to initiate CIRP proceedings against defaulting real estate companies. Now, by virtue of this amendment, NCLT, fortunately or unfortunately, was flooded with applications filed by allottees seeking initiations of CIRP against the real estate companies. As normally it happens, this definition of including allottees as financial creditors was questioned before the Honorable Supreme Court in Pioneer Urban Land Infrastructure Limited, and the Honorable Supreme Court, through its landmark judgment, upheld the constitutional validity of the introduction of home buyers as financial creditors. Now, since NCLT was flooded with applications filed by the allottees, and there was no real adjudication happening of Section 7 petitions, again, there was an amendment in the Section 7 of the IBC Code. And what was this amendment? The amendment was the Insolvency and Bankruptcy Code. Second Amendment of 2020 was introduced on 28/12/2019, which inserted a second provision to Section 7, which introduced a threshold in case of application to be filed by home buyers under Section 7. Now, initially before this amendment was introduced, single home buyer or an allottee could file an application under Section 7 against a real estate company for the non-delivery of its flats, which obviously, as I had said, resulted in flooding of cases before the NCLT all over the country. Then the legislature introduced this second amendment, and has said that not less than 100 of such home buyers in same class or not less than 10% of total number of such creditor, whichever is less, can initiate a CIRP proceedings under Section 7 against a real estate company. The objective of this was that there were no individual home buyer could go against a real estate company for initiation of CIRP proceedings. This threshold was questioned in a judgment before the Honorable Supreme Court in the matter of Manish Kumar versus Union of India. In Manish Kumar versus Union of India, the court upheld this amendment of 100 home buyers or 10% of the allottees, whichever is less. But simultaneous to this, in Manish Kumar, the Honorable Supreme Court also held that assuming there is a real estate company which has multiple projects in progress, the Supreme Court said that the allottees can file a CIRP proceedings against a real estate company against a project which is in default, and hence not against the entire corporate debtor. So which means that CIRP in a Section 7 proceedings, the CIRP will be initiated against the defaulting project, and hence only those home buyers of that particular project in default can initiate the CIRP proceedings. So this amendment was sought, and this was clarified in Manish Kumar's judgment. Now, another important thing that I need to say was that initially the threshold to file a CIRP proceedings or initiate a CIRP proceedings was 1 lakh rupees, which again resulted in a lot of filing of cases. The Government of India, through a notification dated 24th of March 2020, amended Section 4, subsection 1, and increased the threshold limit from 1 lakh to 1 crore. Hence, the default has to be of at least 1 crore to be able to initiate proceedings under Section 7 or Section 9 before any corporate debtor. Now, you would see on this screen that there is a case highlighted, JP Kingston Boulevard Apartments Welfare Association and others versus NBCC India Limited. Now, what is the objective of this case? What had happened once the allottees was introduced and included in the definition of financial creditors, the legislature, in its wisdom, which was right, said that any project which has number of allottees, to allow each one of the allottee to vote in a particular manner, they classified that these allottees would be in a class of creditors. And hence, under Section 25, subsection 3A, the legislature said that they will be an authorized representative appointed by the resolution professional who will vote on behalf of such allottees And to enable him to vote on behalf of the allottees, he would take individual votes of such allottees, and if more than 50% of such allottees voted in favor of a resolution or against a resolution, that more than 50% vote will be held to be the vote of the majority. And hence, this question again was, this fact was again questioned in this judgment. And the Honorable Supreme Court, through Justice Khanvilkar and Justice Dinesh Maheshwari and Justice Khanna, held that if there is a vote more than 50% on a particular resolution by this class of creditors, then that vote will be counted as 100% vote. Now, what would it mean? It means that once a particular resolution has been passed by a class of creditors, then there cannot be any dissenting financial creditor within such class. Which means if they have voted more than 50% in a particular manner, that vote of more than 50% will be counted as a vote of all the financial creditors in a class, and there cannot be any dissenting in such class. Which means that assuming 15% in that class have voted against a plan or against a resolution, they cannot file any proceedings before the adjudicating authority that they were the dissenting financial creditors on a particular resolution. They will be considered as assenting because the majority have voted in favor of a resolution, and they have to then sail through that majority view of a financial creditors within a class. Now, you would see on the screen two judgments, Innovative Industries and Vidarbha Industries. Now, what is the importance of these two judgments? So the importance of these judgments are, if you would recollect, I had said that to be able to initiate a CIRP proceedings under Section 7, what was necessary? That there is a debt due and there is a default in payment of that debt. Now, Innovative Industries, the Honorable Supreme Court in this matter held that the adjudicating authority, while adjudicating upon a Section 7 petition or a Section 9 petition, has to merely see two things: that there is a debt due and there has been a default in payment of that debt. Period. Nothing more. This position of law was altered by the Honorable Supreme Court in Vidarbha Industries Power Limited. Now, what did the Honorable Supreme Court in Vidarbha Industries say? In Vidarbha Industries, the Honorable Supreme Court said that if there is a debt due, then under section that the adjudicating authority in Section 7 subsection 5 has used the word may, which means that under Section 7 petition, the adjudicating authority merely does not have to see a debt or a default. It is the word used is may. I'll just read that provision. Where the adjudicating authority is satisfied that the default has occurred and the application under subsection 2 is complete and there is no disciplinary proceedings or pending against the proposed resolution professional, it may by an order admit such petition application. Now the word may is not mandatory, it is discretionary, which means that the adjudicating authority, while admitting a petition under section 7, has to apply its mind whether the debt was actually due or not, and whether there is a default in that. And if yes, then what it has to give reasons in declining such a petition. Now, section 9, subsection 5. I will take my you to section 9 petition, which is a petition to be filed by an operational creditor against a corporate debtor. But before doing that, section 9, staying on this judgment of Vidarbha by the Honorable Supreme Court, it relying upon section 9, subsection 5 of the code, it said that the word used in subsection 7, subsection 5 is may, but under section 9, subsection 5, the words used are shall, which means that if the condition prescribed under clause A to clause E of subsection 9, subsection 5, subclause 1 of the code are met, then the adjudicating authority has no discretion but to admit a petition. Now, what are these conditions? That one, that the application made under subsection 2 is complete. There is no payment of unpaid operational debt. The invoices against which the goods and services have been provided are there attached to the petition. There is no notice of dispute received by the operational creditor. Now, I'll detail this when I discuss section 9. And the next condition is that there are no disciplinary proceedings against the proposed resolution professional. So this was the position of law that was modified by the Honorable Supreme Court in Vidarbha's case. Now, section 8, section 9, insolvency by an operational creditor. So, assuming there is an amount due for any goods and services provided, then it is a financial debt, as I had earlier explained. And if there is a default in payment of that financial debt, then an operational creditor can file a petition, an application under subsection 9 against the corporate debtor before an adjudicating authority. Now, before it initiates any proceedings under section 9, it is mandatory for an operational creditor to issue a demand notice annexing along with copies of all the invoices where it will demand payment of the debt in default. So there is a distinction between under section 7 and section 9. In case of a financial debt, before initiating a proceeding under section 7, no notice of demand is mandated to be served. But before initiating a proceeding under section 9, it is mandatory for the operational creditor to deliver a demand notice. Now, once a demand notice is delivered, it is the corporate debtor has been provided a period of 10 days from the receipt of the demand notice to inform the operational creditor of existence of any dispute if there is against that claim. And if the corporate debtor has served a reply raising a dispute against the goods or services provided, or has raised a dispute against the delivery of those goods and services, then ordinarily the adjudicating authority normally would not admit such a petition. Now, application for initiation of CIRP. Assuming there is no receipt of any reply on the demand notice that is received, then the operational creditor will file a petition under section 9. Now, I'll clarify something over here. The demand notice has to be issued under section 8, and pursuant to the issuance of the demand notice, the proceedings can be initiated under section 9. Now, once a proceeding under section 9 is initiated, the application that is filed before the adjudicating authorities has to be accompanied by certain documents which are mandatory in nature. Now, what are those documents? Those documents are copy of the invoices against which the goods and services have been provided, copy of the demand notice delivered by the operational creditor. There has to be an affidavit which will specify that no notice related to any dispute was given by the operational creditor. Then there has to be a certificate, a banker's certificate from the financial institution that no payments have been received in this account from the financial creditor, the operational corporate debtor. Then there is an information utility provided, the copy of the record of that information utility, and any other proof of payment. Now, the adjudicating authority, as I had said in section 9, subsection 2, I had read earlier, if the application is complete, no payment of any operational debt, and there is no proof of any payment of operational debt, the invoices against which the goods and services have been provided, notice for payment of the corporate debt delivered by the operational creditor, notice of dispute not received, no disciplinary proceedings against the proposed resolution professional, then ordinarily the adjudicating authority will admit such petition and initiate CIRP proceedings against the corporate debtor. This position of law, the Honorable Supreme Court in Mobilox Innovative Private Limited has held to be mandatory, and has said that if there is all these above conditions are complete, then the adjudicating authority will initiate proceedings against the corporate debtor under section 9. Now, friends, I will now take you, after discussing section 7 and section 9, I will take you to the time frame of CIRP proceedings. Now, CIRP proceedings are time-bound proceedings. Initially, under section 12, the CIRP proceedings were to be completed in 180 days from the date of commencement of the CIRP proceedings. Now, what is the date of commencement of the CIRP proceedings? The date of commencement of CIRP proceedings is the date when that order of the adjudicating authority is passed, initiating CIRP proceedings. Now, this period of 180 days initially could be extended by 90 days. Hence, initially, the mandated period to complete CIRP proceedings was 270 days. Now, this 270 days was subsequently amended, and a second proviso to section 12 of the code was introduced, which said that beyond this 70 days, another 60-day window was provided, and hence the CIRP proceedings were increased to 330 days. Now, exclusion of intervening period. Now, these exclusions have not been quantified in the code, but there are certain number of days which have been held, can be legally be excluded from this period of CIRP period of 330 days. And what are those days? Which was actually qualified by the Honorable NC-LAT in Quinn Logistics. Now, what are those days? Whereas CIRP proceedings is stayed by any court or any adjudicating authority, that the resolution professional appointed pursuant to the initiation of CIRP proceedings is not functioning for one reason or the other. The period between the date of order of admission is passed and actual date on which the resolution professional takes charge for completing the CIRP. Next, if the order is reserved by the adjudicating authority or the appellate tribunal or the Honorable Supreme Court, that period of reserving of the order is required to be excluded from the period of CIRP period of 330 days. And if the CIRP period is set aside by the appellate tribunal and reversed by the Honorable Supreme Court, that period can also be excluded from the CIRP proceedings. Now, so I have largely discussed and detailed upon and touched those provisions which are the important provisions while a CIRP proceedings have to be initiated and under what circumstances can they be initiated. Now, friends, I will so friends, I have detailed this chart. This chart details the timeline for the commencement of the CIRP proceedings of a corporate debtor if initiated under Section 7 or Section 9. Now, I'll take you one by one. So I have made 3 columns. This is the description, then the duration, and then the maximum duration. Now, first says commencement of the CIRP and the appointment of interim resolution professional. So this is done once an order of CIRP proceedings is delivered by the adjudicating authority. So the maximum duration I have referred as T, and basis this T, I will detail the number of days that are mandatorily there. Now, once the CIRP proceedings are initiated, then a public announcement has to be made by the interim resolution professional. Now, that public announcement has to be within 3 days of the passing of that order initiating the CIRP. Now, once that publication is made, that publication is in Form A. There is a form provided, that publication is in Form A. Then once that publication is made, the nature of that publication is that the IRP will invite claims from various claimants who to whom that money, any money is owed by that corporate debtor. Now, that those claims have to be filed within 14 days of that public notice. And you will here see the last date of submission of claims, which is under regulation 12(2). Now, the claims can be filed within 14 days, but cannot and have to be filed within 90th day of the initiation of the CIRP proceeding, which means beyond 90 days, no claims filed will be entertained by the IRP. So the 90-day period is sacrosanct, which have been held by the Honorable Supreme Court in Ghanshyam Mishra's case. So once these claims have been filed, there is an obligation on the IRP to complete the verification of such claims within 7 days of its filing, or within 7 days of the 90th day. Assuming any claim is filed on the 90th day, then it is 7 days from that night. So he has a window of 7 days to complete the verification of those claims. Now, I have been using this word IRP, which is interim resolution professional. So once interim resolution as professional is appointed, he has to be confirmed as a resolution professional. So I'm sorry. Once this form A is filed, I missed out this part. Once a form A is filed, a public announcement is made, assuming the public announcement is made for a corporate debtor, which is a real estate company, then as I had said earlier, I had discussed earlier that there has to be an authorized representative appointed for a class of creditors. So the interim resolution professional in that public announcement in form A have to give names of 3 interim resolution professionals, and the allottees of that project in a class out of these 3 names have to vote in favor of one of such persons, and such out of those 3 persons, who receives the maximum vote out of such class of creditors will be appointed as the authorized representative. Now, once this is done, within 2 days of the verification of the claims, the first time the verification, which is 21st day, within 2 days of that 21st day, a COC has to be constituted. The COC is the Committee of Creditors, which largely is of financial creditors. The Committee of Creditors will pass any resolutions, and that resolution has to be then worked upon by the resolution professional. The first COC meeting has to be held within 7 days of the constitution of COC. And once the COC is constituted, the COC in its first meeting will confirm or appoint another IRP as a resolution professional. So the Committee of Creditors have an option to either confirm the interim resolution professional appointed by the adjudicating authority in its order, or if they are not comfortable with that interim resolution professional, then they can, by a vote of majority, 66% by a vote of majority, can appoint another interim resolution professional as a resolution professional. Once an IRP is appointed, then there are certain functions that he has to perform, which is appointment of the valuer. Once a valuer is appointed, then he will prepare an information memorandum. What is this information memorandum? The purpose of this information memorandum is to give a background of the corporate debtor and the details that are required. He will prepare this information memorandum, submit it to the COC, and COC in its wisdom will approve or suggest changes in the information memorandum. Once an information memorandum is finalized, then the interim resolution professional will publish Form G. Now, what is the purpose of this Form G? Form G is for inviting expression of interest. Now, friends, very important, CIRP proceedings are not a recovery proceedings. CIRP proceedings is resolution of a corporate debtor. What does resolution of a corporate debtor means? The resolution of a corporate debtor means that if there is a debt and there is a default, and that default exists and that debt is unpaid by the corporate debtor, that then there will be an invitation from various other corporate debtors or a combination of other consortium of people who will file their expression of interest to take over the management and control of the corporate debtor. The purpose of expression of interest is inviting those expression of interest. Then within 15 days of submission of publication of Form G, a 15-day period is provided for submitting of expression of interest. Once that 15-day period is over, then the resolution professional is obligated to issue a provisional list of resolution applicants. Now, that provisional list would mean that that list is published. It is put on the website of the corporate debtor. Against that provisional list, there is a window provided to file objections against those provisional list of resolution applicants. Once, assuming there is no objection, then there is issuance of final list. That final list has to be 10 days from the receipt of objections, assuming there are no objections, then within 10 days of the issuance of the provisional list. Once the resolution applicant list is confirmed, then there is issuance of RFRP, that is request for resolution plan, evaluation matrix, and the information memorandum. I will skip then once the resolution professional has taken charge, then within 115th day of the initiation of CIRP proceedings, he has to identify if there are any preferential transaction, if there are any undervalued transaction, or fraudulent transactions, or wrongful trading of transactions. Then he has to identify. And once he has identified this within 115th day, then within 20 days of that 115th day, he will have to file an application under the relevant provisions, section 45, section 49, section 66, where he will file proceedings of bringing to notice to the adjudicating authority and requesting the adjudicating authority to declare such transaction either as preferential transactions or undervalued transaction or fraudulent transaction. So once this entire process goes, simultaneous to that process, the resolution applicants, after the final list of resolution applicant is prepared, they will be issued the information memorandum, they will be issued the evaluation matrix and the RFRP. Basis these documents, those resolution applicants will, in their wisdom, file a resolution plan. Now, that resolution plan will have a lot of details. Now, those details are mandated in section 30, subsection 2, in regulation 37, in regulation 38, and regulation 39 of the CIRP regulation of corporate persons. And basis those regulations, they will prepare a resolution plan. Those resolution plans will, assuming there are 5 resolution applicants who have filed resolution plans for the corporate debtor, then those resolution plans will be discussed in the meeting of the committee of creditors. And basis those discussions, those resolution applicants will be given an opportunity to modify their plans in pursuance to those discussions. And once those final resolution plans have been submitted to the committee of creditors, the committee, those resolution plans then will be put to vote before the committee of creditors. And once they have been put to vote, one such plan will be passed by the committee of creditors, provided that plan receives a minimum of 66% of vote. So assuming no plan receives 66% of the vote of the committee of creditors, then it is not a successful resolution plan. And then probably the wheel would have been to be reinvented by the resolution professional. But assuming there is a plan which has received 66% of the vote of the committee of creditors, then a letter of intent has to be issued by the resolution professional in favor of that resolution applicant whose plan has received 66% of the vote. Once that is completed, the resolution professional will then file an application within 30 days to the adjudicating authority for approval of the adjudicating authority on that plan which have been passed by the committee of creditors. Now, gentlemen, it is important to also highlight that under what circumstances can an adjudicating authority decline the approval of a plan. Now, 2 judgments passed by the Honorable Supreme Court in Satish Kumar Gupta and K. Shashidhar, where they have held categorically that the adjudicating authority must not go into the commercial wisdom of the committee of creditors. The only ground for interference which is mandated or required by the adjudicating authority is that if such plan that has been approved by the committee of creditors, the necessary conditions that have been provided in the code, which is section 30, subsection 2, subclause B, or the necessary mandatory conditions which have been provided in regulation 37, in regulation 38, and regulation 39. If these conditions are not there, not available in that successful resolution plan, only then can an adjudicating authority decline the approval of the plan. And other than these, the adjudicating authorities is not required to go into the commercial wisdom of the COC. And if any plan which is all these conditions are there available in the plan, then the adjudicating authority ordinarily will approve such resolution plan in favor of the resolution applicant who's filed such plan. So this is the entire process of CIRP proceedings. Now, Insolvency and Bankruptcy Code is a very large statute, but these are what I have just explained or tried to make myself clear are largely the provisions which are important provisions in any CIRP proceedings. Friends, I thank you for your patient hearing, and I hope I've made myself clear. I once again thank Diksha and Law Leveler for giving me this opportunity to present this Introduction to Insolvency and Bankruptcy Code. Thank you very much. Have a nice day.